To start, we want to thank the steering committee here that you can see on the screen. The steering committee has done a great job of coming together to come up with topics for the fall and into the spring, just that are relevant and timely, and using the different experiences to come up with different topics relevant to all of our different sizes of business. Speaking of the topics, if we go to the next slide, we've got several events coming up this fall. So September 17th, putting practices and fundamental changes in place for diversity. October 22nd, rethinking what is possible in M&A, and December 3rd, new world of finance in the age of uncertainty. Topics that the team came together and just felt were relevant as we were headed into this season of uncertainty that we've got going on now. We go to the next slide. We want to thank, in particular, our sponsors, Adaptive Insights, Bank of America, Baker Donelson BDO, NetSuite, Insperity, and Baco. We're very thankful to all the work that they've put into the chapter. They are bring lots of content and experts to the panels to help share information with all of us, and we appreciate all that they bring to the chapter themselves. Okay. If you want to follow us, you can follow us at CFOLC.com, on LinkedIn, Twitter. Follow us. In particular, if you go to the CFLO Leadership Conference website, you can find all the events that are going on around the country. In particular, one of the things you can do is you can join the community. You can become a member. There's different annual membership options, from options to where for totally virtual, or that would have some in person as we start to come back to them. Right now, there's an August special on the premium membership, $100 off, and until August 31st, that would also include the CFO Leadership Conference that will be coming up later this fall. As you join the community, some of the things you will see will be there are program recordings. As we do the different webinars throughout, similar to this one, they are put into some program recording resources for our members only, where you can go and access those based on different topics at any time and at your own pace. Today's programming is going to be on HR and employment update, diversity and discrimination, what you need to know. Our speakers will be from Baker Donelson. First, we've got John Scannapieco. John is primarily in global operations, helping companies with their global expanse from Asia, Europe, Africa, United States, developing the agreements within the different regions. Martha brings a expertise in employment and helping companies create handbooks, helping companies understand their responsibilities to employees and their different understanding of the benefits and different types of opportunities that they provide employees, as well as how to prepare in the case of needed legal help, depending on the situation related to employments that we've come into. So from there, I think we'll kick it over to John and Martha to lead the presentation.
Well, thanks, Jay and Jennifer. We appreciate the opportunity to speak to everybody today. We know there is a lot of uncertainty, as Jay has already mentioned, especially when it comes to your workforce, and how do you manage your workforce during these very challenging times. And so what Martha and I thought we would do today is engage in somewhat of a question and answer kind of fireside chat format. But please throw your questions into that chat box. I'm going to open it up on the side here so I can see it as you are as we're speaking, so that we can maybe weave some of your questions into our conversation. So with that, I'm going to start. And Martha, let's kind of lay the groundwork here today. You know, as much of the relief offered to employers under the various stimulus and aid packages that have been passed by Congress since the shutdown occurred back in March, as they start to wind down, and our economy, unfortunately, is still being adversely impacted by the demand shock that was caused by the coronavirus, many employers now are being forced to adopt a variety of cost-cutting measures that includes furloughing, or in some cases even terminating, reducing the number of their employees in order to try to save their business. Now, while I don't believe in at least my professional experience, I've been practicing law for about 30 years, I don't think we've seen such a significant economic downturn, but we've had some fairly significant ones, like, for example, the 2008, 2009 financial crisis, when employers were faced with some similar challenges. What can employers expect when they adopt maybe furloughs or significant force reductions, including layoffs and terminations? What can they think it may be coming down the pike?
Sure. So what we know is that more people sue during periods of economic recession. And we know that because we can look at the data from the 2007, 2008, many of our minds. And in that period of time, so the unemployment rate in late 2007 was a little less than 5%, and it jumped pretty quickly to about 10% by the fall of 2009. During that same period, the number of workers who were displaced from jobs that they had held for 3 years or more doubled. So you had a ton of folks out of work all of a sudden. They also had a hard time getting reemployed. The reemployment rate was low, and when they did get reemployed, they were earning less money than they did previously. So we saw, along with that, an increase in wrongful discharge claims of about 21% during that time period. And this compares with a 14% increase in layoffs and displaced workers. So you can see that the number of, or the percentage of people who sued is even greater than the numbers of displaced workers. And I think the reasons for that are primarily the sort of obvious one, desperation. I mean, I think when people get into a crisis like this, they are laid off from a job that they've held for a long time, and they have a hard time finding a new job. And then they have a hard time finding a job that is as lucrative as their previous job. The tendency is to sue. And I mean, I think we've got to consider, one population that was hit particularly hard in the 2008 to 2011 recession was older folks, people so over the age of 40 or 50 or whatever. They have a harder time finding work. And, I don't know if that's, they didn't have the skills, or there's just sort of a bias in our society, but those were a large part of the lawsuits that were filed. So what we want to talk to you today about is sort of positioning your company to weather this economic crisis. So, we can't protect you from being sued, but what we can do is help you have the best defense that you can have if you are sued, so that you avoid major liability from these types of claims.
Well, what steps, or are there steps that employers can take now to maybe minimize the risk that maybe they will get sued or have, EEOC complaints or other kinds of complaints filed against them, and then if they do get the lawsuit or they do get the complaint, that at least maybe they can set themselves up to mitigate that risk, that maybe they'll suffer an adverse judgment, or they can minimize even that judgment?
Yeah. I think the most important thing for you to go back to your companies and look at immediately is how you discharge employees, how you let people go, because that's what this is going to be all about. And I want you to look at your policies. I want you to look at your practices. I want you to look at how you select people for layoff or termination. I want you to look at what you require as a company before somebody in your company is able to terminate an employee. And we're going to talk about a lot of these issues today, but this is the time. So we know where, we're sort of on this precipice right now, where it seems like the economy is going to maybe, start to decline. And so we need to be prepared now to make sure that when you discharge employees for whatever reason, you're best set up in each case to be protected.
Well, but I mean, I always thought, and I know Tennessee is, for example, an at-will employment state, and I know many states around the country have adopted have for a long time, especially in the South, but also now other parts of the United States are adopting this employment at will. And I thought that just meant, well, I can fire you anytime for any reason. Like, I don't like the fact that you wear glasses, you're fired. I mean, I thought I could just do that and get away with that, and that would be, I can just wipe my hands and I'd be good.
Yeah, so I hear that all the time from employers. They'll call and say, we're going to terminate this person, but it's an at-will state, so we can do whatever we want. And that's cool. So Tennessee, like most states in the country, is an at-will employment state. And this technically means that an employee can be discharged with or without cause, with or without notice, all that. But there's a ton of exceptions to the at-will status. For example, you can't terminate somebody because of their race. You can't terminate somebody because of their sex, because of their sexual orientation, because of their age, because they have a disability. Or you can't terminate somebody because they've engaged in protected activity of some sort, like they filed a workers' compensation claim, they complained about sexual harassment, they took a legally protected leave, like under the Family and Medical Leave Act or under the new Families First Coronavirus Response Act. So if they're in a protected status, you can't terminate them for that. And you can't terminate them because they've engaged in protected activity. And these exceptions really swallow the rule. Because if you don't give an employee a good reason for terminating them, or you just say, well, you're fired, we don't have to give you a reason, they're going to assume that the reason is illegal. So they're going to immediately go to, well, they didn't give me any reason that made sense to me, so it must be my age, or it must be because 3 months ago I complained about my supervisor harassing me. So I want people to get the term at will out of their heads. It is really meaningless. The thing is, you should always have a good reason to terminate an employee. And think about it this way. I call termination the capital punishment of employment law. And I want the kinds of, I want my clients to have the kinds of procedures in place to make sure that termination is correct. Because think about it, I mean, like, you're terminating somebody, they may not be able to pay their mortgage in 3 months. They may not be able to send their kid to college. So this is a decision that you need to make with a lot of thought and a lot of consideration, and make sure that what you're doing makes sense and it's fair.
Yeah, but and I hear you, and I think that is very good advice. But a lot of times, I mean, I've seen this in some of my clients as well. The reason for the termination, the client just doesn't want to lay it all on that person to say, look, you're just not a really good worker, or there's some other legitimate reason. And so they end up, I don't know, giving them the, it's not you, it's me kind of thing that we are all familiar with probably in our dating life at some point, getting told that it didn't work out well then in that environment. And how does that work in, say, the employment, arena?
So that's a great question. It's really important to come up with a good reason to terminate somebody and not to sugarcoat it. So I had a client a long time ago who told this terrible employee, I mean, she was terrible. She did all sorts of terrible things. And when they terminated her, they said, we just think that you're not happy here. And she's like, no, I'm happy. And they're like, no, we don't think you're happy. And so they terminated her for that. And that was bogus. They had lots of good reasons to terminate her, but they just didn't want to tell her that. So they avoided it with this, you're not happy. And she was like, no, I was actually really happy. And, you shouldn't have terminated me. And that was kind of a hard lawsuit to defend. So you need to make sure you have a good reason and you communicate that reason to the employee. And obviously you want to be compassionate in the delivery. You don't want to, you want to protect the person's feelings to the extent possible, but you've got to be 100% honest with them about the reason for the termination. And this means that you have to really have thought about the reason. You have to really agree on the reason. So if there's several decision makers in the room, if you've got HR and a supervisor and a manager, all deciding we're going to terminate this person, everybody needs to agree. What's the reason? What are we going to tell this person? And do we all agree that that's the real reason? Because if this employee ends up suing you, you're stuck with that reason. You're stuck with what you told them. You can't go back later and tell a court, well, we told them this, but it was really a whole bunch of other things, because then you look like a liar. So you really got to spend some time coming up with what is the reason we're going to give this person for terminating her, and are we all in agreement that this is the real reason?
Well, I'm a process-oriented person, so I've heard a lot about progressive discipline policies or systems. Well, first of all, what is a progressive discipline policy, and is that something maybe that an employer should consider adopting, so that maybe there's some structure there, through this process, so they end up with a good reason and then a good process when they actually maybe have to tell an employee, I'm sorry, but we're going to have to let you go?
Yeah, so progressive discipline policies, this is another term that people sort of use without understanding what it means. True progressive discipline policies are kind of a holdout from the days when unions negotiated collective bargaining agreements with employers, and they insisted that there be increasingly severe steps of discipline. So typically it went something like oral warning, written warning, a second written warning, suspension, and then discharge. And in the union setting, employers are strictly prohibited from skipping those steps. They have to go through all the steps before they discharge. And sometimes under those policies, the earlier steps actually roll off if the employee hasn't done anything bad in a particular period of time. So if the employee had a terrible attendance record, but they go 6 months and they don't have any more problems, all those previous attendance issues roll off. If you're not unionized, you should not have a progressive discipline policy. And you would think that people would not have these because they don't have to. They really tie employers' hands. But I had a client who called me recently, not unionized. I don't know where they got this policy, but it was a progressive discipline policy where offenses rolled off after a certain period of time, and they had an employee they wanted to terminate, and they could not terminate this person because they had to follow all these steps first. What you probably have and what you should have is what I would call a modified progressive discipline policy. This doesn't require you to follow lockstep the various steps of discipline before you go to more severe. It allows you to select the appropriate level of discipline for the particular offense and considering all the other circumstances. So you'd want to consider, for example, had the employee engaged in similar misconduct in the past, or is their performance consistently poor? And what was the employee's excuse, and all these things. So when you start examining your disciplinary policies, look at this one first and just make sure you don't have a true progressive discipline policy. And when I draft handbooks, I usually say, if the employer has, this is a progressive discipline policy, I take that out. It's not, it's a modified progressive discipline policy. And I often say specifically, the employer can choose at its discretion the appropriate level of discipline for the offense. So go back and take a look at your policies, see what they say, and make sure you've got the discretion to select the appropriate level of discipline. And if you don't, it's time to revise that policy.
Well, one area I know that employers are considering right now are reductions in force. So, we've kind of talked about we should have a good reason, right, before we terminate, and maybe some policies that they should consider when terminating. But what recommendations can you maybe provide to the folks that are listening as the, some maybe best practices as ways to select these employees that maybe they're going to then eliminate from their employment?
Sure. So the surefire way to avoid a lawsuit in a reduction in force is to select the employees by seniority. That is, the last in or the first out. It's almost impossible for somebody to sue you for that if you follow that methodology. But it's also one of the worst methods you can use. And here's why. So if you have a strict last in, first out layoff policy, your more senior employees, the folks who've been with you longer, are disincentivized from performing well because, they're good, they're protected, like they're not going to be laid off. But your junior employees, your recent hires, are also disincentivized from performing well because what does it matter? They're going to be slashed regardless of what they do. And plus, what if you just hired some really great folks that you're depending on that you want to keep? You don't want to get rid of those folks just because they were last in the door. So I get why employers want to use seniority. And if you're talking, if your employees are generally fungible, I guess you could use that method, but I think there's other methods that are better for protecting your company. One would be using a status-based selection. So let's say you have employees who are temporary or contingent, or maybe you're using folks to sort of part-time. You could lay those folks off first. So that's an objective category that you could use. And that way you're protecting your regular full-time employees and letting go sort of the folks who are a little bit on the margins. Another one to do it would be a merit-based selection. So this is really looking at your employees and how they perform, and is their attendance good and things like that. The obvious problem with this method is it is very subjective. So you're relying, for example, on employee performance evaluations in the past, or employee discipline, and hoping that those evaluations and the discipline were not the result of bias on the part of a supervisor or something like that. So these are that's the harder way to do it, but that way you get to retain folks who are ideally your best performers. Another way to do it would be a skill-based selection. So often you have people who you've hired maybe recently who have a particular skill that you hired them for that is unique in your company, and you need that skill going forward. And if some of your other employees don't have that skill, those should be the folks who are laid off, not the ones that you just hired with that particular skill. And again, that's a subjective, somewhat of a subjective evaluation that you're going to have to make. But the bottom line is, you don't want to lose your best employees because you use an objective measure that ultimately ties your hands in terms of your ability to perform with a reduced workforce going forward. And be aware that
is there something? Oh, go ahead. Sorry, go ahead.
Yeah, be aware that you don't have to use the same methodology in every department. So you might say that in a particular department, seniority makes sense because there's no real way to distinguish between the employees, and we feel like this is the fairer way. In another department, maybe it is the skills based. In another department, maybe it's the merit based. Whatever you do, you need to document the method you used and then document why you selected the employees you selected using that method.
Well, when we talk more, the objective, I think, measurements or tests, however we're going to want to call it, I think that is easier to document because there it is. I mean, either, seniority, I've worked this long, or some of the merit, maybe my evaluations over time. But with the other subjective kind of approaches, are there any best practices that employers can follow so that they can, again, mitigate the risk that someone can call into question then how they evaluated or what they evaluated?
Yeah, so I think one of the things to look at, so anytime you're making a decision on a subjective basis, the employee's performance, I think you want to look at a variety of measures. So, for example, one thing I often see when I get a call from a client who says, we want to terminate this employee for poor performance, is I say, great, okay, let's look at the last performance evaluation and let's see what it says. And we look at it and it's stellar. There's nothing to indicate that this employee's performance has been substandard. So, I think a good first step, if you're going to use one of these more subjective measures, is to look at your performance evaluation system and decide if it is working for you. Because if you have supervisors who are all using different ways to do their performance evaluations, some may be providing helpful feedback in the evaluation, and some are just checking the block and giving everybody a 3, and there's no real feedback. If that's the system you're using and it's all over the board, you're going to have a problem when an employee sues you saying, why was I selected for reduction when my performance was just as good as somebody else's, as according to my performance evaluation? So I think that's another step for you guys to take, sort of going back to work, is to look at your system and see, is it fair or is it really flawed? And a lot of employers have tried a variety of performance evaluation systems over the years, and these are hard. It's hard to come up with a good system, but one step you need to make if you have a performance evaluation system is to train your supervisors on how to use that system. So don't just hand it to them and say, this is the performance evaluation we're going to use. Actually train them. Here are the expectations. Here's what we expect to see. We expect to see you actually spending time and putting text in the evaluation so the employee can understand where their deficiencies are and what they need to do to improve. And here's how we're doing the rating system. If you're rating folks or giving them a score of some point, here's how we do it. So don't just have a system that supervisors use sort of willy-nilly. Train them on it and make sure it's a system that makes sense.
Well, one of our participants has asked a question, is cultural fit a valid criterion, in a performance evaluation type measure when I'm thinking about maybe reducing my workforce?
Yes, that's a great question. Cultural fit is one of those terms, sort of like attitude, that is really problematic. So cultural fit can be lingo for, this person isn't the same race as everybody else and they don't seem to see the world the same way we do. And so this person makes us uncomfortable. So cultural fit is a really problematic basis to terminate somebody. But look, what you can do instead is translate that cultural fit into something that makes the person less effective on their job. So, for example, if the person is unprofessional in the way they communicate with their coworkers or with customers, they're really in your face, they're really aggressive, they get nasty, they're impatient, that's a good reason to discipline or discharge somebody. Or if the person is not, doesn't have the same sort of motivation as others, seems not to take the initiative, will never go outside the four corners of their job description, doesn't address problems as they arise, lets them fester. I mean, those are good reasons to terminate somebody. But just cultural fit, really can be sort of, a euphemism for discrimination. And so that's a term we really want to avoid. You really want to look at what is the person doing or not doing in their job that makes them less suitable for this job. And that's where you need to focus.
Or maybe looking at, and again, I don't know if this is a good idea or not, but looking at what is my culture and defining that. And well, they don't, for example, team play, or as you say, customer service or something along those lines, and then breaking that down right? And then maybe tying it that way. Okay.
Yeah,
Okay.
exactly.
Well, now,
Exactly.
okay. Now, I've seen lately, and especially this is more true right now anyway, in the hospitality sector, here, say in Nashville, where I've seen a company that maybe owns and operates some hotels, and they're laying off or terminating, 200, 300 employees. Are there any requirements that an employer must satisfy in order to be able to lay off, that many people? Or can they just do it?
So, yeah, no. So there's a law called the Federal WARN Act, and there are state mini WARN acts. And WARN is an acronym for Worker Adjustment and Retraining Notification or something like that. WARN, WARN. So the WARN Act requires employers of a certain size who are conducting a layoff of a certain size to provide 60 days advance notice of that layoff. It's a layoff or a plant closing. Basically, if you're doing a big layoff, you have got to look at the WARN Act. And if you don't give that by the way, that 60 days advance notice, that employee needs to remain employed during that whole 60-day period. So if you're thinking about doing a layoff in the next few weeks, you need to look at the WARN Act today and give that WARN Act notice. It requires you to give notice to the employees. It requires you to also give notice to the mayor and the the state worker dislocation unit for your state. So, and most states also have what they call mini WARN acts that are a little less oppressive. But the bottom line is you've got to follow the WARN Act law, and it's really nuanced. There's a lot of holes in the law. There's a lot of ways you can get caught. And the liability can be really significant. So if you don't give that notice, you can end up owing that employee the wages and benefits they would have received for that 60-day period, even if you termed them, a week into it. Now, there are some exceptions that may be helpful in this context. There's one called the unforeseeable business circumstances exception. And this is a really narrow exception, but it's for mass layoffs or closings caused by business circumstances that were not reasonably foreseeable at the time that 60-day notice would have been required. So if we look back on March, all of a sudden we have this pandemic. All of a sudden people are getting sick. All of a sudden the cities are telling employers, you can't operate right now because, it's dangerous. That's the kind of unforeseeable business circumstance we would want to see. I mean, something that was so, unforeseeable, something outside the employer's control that the employer could not have anticipated. An unforeseeable business circumstance is not just, things started sliding, the demand for our particular product or service declined because, let's say we were just talking about this gas station, you're no longer selling gas because nobody's going anywhere, that kind of thing. That's not probably an unforeseeable business circumstance, although we would make the case if we had to. But you've got to really look at what are the things we could not have anticipated here. And if that exception applies, you would only need to give notice from the time you realized you had to make the layoff. So if you decided 2 weeks later, we're going to have to do this big layoff, you give the notice today and you argue that exception if you get sued under the WARN Act. But really, I would encourage anybody who's looking at a big layoff like that to get with your legal counsel and see what these WARN Act notices need to look like.
So it potentially could be problematic today because, of course, the shutdowns occurred back in March. In Tennessee, for example, we've been out of the shutdowns now for quite some time. Although there's still some, like for example in Nashville, there's still some limited shutdowns. It would be harder for me today maybe to argue the unforeseeable business circumstance because, as you say, it's maybe been this this slow decline versus that abrupt, hey, you have to close right now kind of thing. Is that okay?
I think that's right. And I mean, I guess you could argue, well, it wasn't foreseeable that we wouldn't have a vaccine by, the fall or something like that. And again, we're used to making these creative arguments when we need to do so, but to the extent you can forecast a little bit ahead and think about what does our workforce need to look like in November, December, it's best if you can go ahead and make that forecast and give that notice so you're not stuck trying to rely on an exception that may or may not apply.
Okay. So now what about in cases of just, pure termination? So I just want to literally, I've had enough with either one or more employees, and I just want to, pull the plug on the whole thing. What should the employers be thinking about before they make that determination and terminate what we'll call underperforming employees?
Sure. And this has come up a lot because, at a time when everything is contracting, you need your employees to be at 100%. You need them to be performing well.
Right.
And so when you've got some that are underperforming, they really stick out in this environment when, everything is economically uncertain. So the first thing you want to think about is, again, go back to that performance evaluation and see what does it look like. And if it's awesome, and the supervisor now is like, oh, this person's terrible, you got to hold the supervisor's feet to the fire a little bit and say, well, the performance evaluation would give this employee no reason to believe that his performance is terrible. And so I'm typically going to advise an employer in that situation to give it some time, for the supervisor to provide real meaningful feedback about the employee's performance. So the employee knows, my performance is not up to snuff and I'm going to lose my job if it doesn't change. And then just some other things to think about is, how long has the employee worked in the particular position and has their performance changed in some way? I often get employers who say, this employee is terrible and we need to get rid of them. And I'm like, but they've been in this position for 8 years. Like, what has changed in their performance? And sometimes there is something, sometimes there's been some sort of issue outside of work that has distracted them, or they've gotten an attitude, like an entitled attitude or something like that. But sometimes it's just, well, nothing's really changed. We just don't really like the person anymore. And then we really need to talk about, let's make sure we have told this employee that, they're at risk here. You also want to look at whether the employee was adequately trained for the job. So sometimes the performance deficiencies aren't a matter of lack of motivation or desire, but just they don't understand how to do the job. And then, how do you quantify the performance deficiencies? Are they objective or subjective? And start to build that record. So if you've gotten unhappy emails from customers saying, Frank, I was dealing with Frank and he was really nasty to me and he didn't give me some information I needed to understand that this product we have was going to be late, save all that. That's good stuff. I mean, that's really like something you can hold up to a court and say, this is our best customer and they weren't servicing them well. Make sure that they have been counseled on their performance deficiencies, and make sure that they have been told if they don't improve, they will be terminated. The bottom line is an employee should never be surprised by a performance termination. They may claim surprise, but honestly, you should be able as a company to hold up a record and say, to the extent this employee is claiming they didn't see this coming, that's ridiculous, because here's the entire record. There's a performance evaluation that was substandard. Here's 3 counseling statements on this type of performance deficiency. So, and here's where in the last one we said, if your performance doesn't improve immediately, you're going to be terminated.
So we've talked about now just the general reduction in force, right? I just need to lay off some employees, no one in particular, but then I go through that process. We've talked about underperforming employees. Now let's kind of turn to misconduct. And if you could, and this they may be similar, they may be all the same, but I think I'm seeing a lot in the news, for example, and our clients are calling. Let's say, for example, I have a mask policy at my company, and an employee won't wear a mask. I have, or we're seeing also some employees just refusing to return to work because they don't think it's safe. And then even now, recently I saw, and the president got involved a little bit with Goodyear, I think with one of their stores, I think it was a Black Lives Matters versus, I think it was maybe a pro-Trump kind of distinction. But, on this political stuff, especially now as we're heading into what looks like it's going to be a very contentious election period where I think people feel very passionately about these issues on all sides. So can you weave kind of that into that? So if I want to get rid of somebody for misconduct, and maybe how do I do it in a way that I'm going to be able to defend that? Again, to maybe reduce the risk I'm going to get sued, but if I do, that I give myself the best chance of prevailing.
Sure. So the first thing I would say is you want to make sure, how would your employee know that their action was misconduct? And I get it. Not all policies and practices are written down. I mean, you've got an employee handbook, right? But you're not going to anticipate every single thing an employee might do wrong. But in general, your employee's misconduct needs to fit some general category of prohibited activity, so they'll know they did something wrong, even if it's insubordination. You want to make sure that the reason for the discharge has been investigated. And this doesn't mean you have to hire an outside private investigator and do a 3-week interview of every employee in the facility, but you need to do at least some sort of investigation so that you talk to witnesses, you talk to the supervisor who saw the misconduct. You want to get other people's sides of the story, and you want to take notes from your conversations with witnesses. And for goodness sake, please don't just give a witness a piece of paper and say, write a statement about what happened. Because I can tell you what you end up with is a statement, I've seen this in many cases, that says, I didn't see nothing, and a signature that I can't read, and there's no date, and we don't know what they're talking about, and that's what we have to support our discharge. So as a supervisor or an investigator or HR person or CFO, you need to be the one interviewing the witnesses and taking notes from your interviews. You need to make sure that you talk to the employee, him or herself. I've been shocked sometimes by clients who say, we want to fire this person because they did X misconduct. And I say, well, what do they say about it? And they're like, well, we didn't talk to them. So you actually want to talk to the employee. Why? Because often that employee will cough up some helpful information. Sometimes they'll actually admit that they did something wrong. And that's really helpful when you terminate them, and you can show that later to a court. Or sometimes they say something so completely inconsistent or ridiculous that you can use that against them later on. But you definitely want to get their side of the story, because, every now and then somebody said, the employee says something that you're like, we didn't realize that. That paints an entirely different scenario to the picture. So make sure you talk to the employee themselves. Make sure you've gathered and preserved any documents that you need. Make sure that the reason for discharge makes sense. And I always say, put yourself in the position of a juror. So it's a year from now, you're a juror in the trial where this employee has sued you. And you have given this employee, this is why we terminated them for this kind of misconduct. Is that going to make sense to a jury? I mean, does it sound serious enough? So kind of run that through your mind. And just to kind of come back around to the issues that John raised, the mask issue. So this is a really difficult issue for employers. For the most part, if you tell your employees to wear a mask, they've got to wear a mask. That's a valid thing to tell them. It's a valid requirement. It's the guidance from the CDC, and your employees should be following that. Now, you may have an employee who claims to have some physical disability that prevents them from wearing a mask. Like, I don't know what those things are, but people have been claiming that. If that's the case, or a mental disability, and there are mental disabilities that prevent people from wearing masks, if that is the case, you would want to get that employee to go to their doctor and get a note saying, this is what this employee is dealing with, and this is why this employee needs to not wear a mask. That doesn't mean, though, that that employee gets to walk around your workplace not wearing a mask. That just means that maybe you give that employee a leave of absence because they can't work safely in your facility. Or maybe you give that employee sort of a cubicle in a corner where they're not interacting with other employees, or something like that. But in general, if you tell your employees to wear a mask, they wear a mask. And the sort of political, like, well, I don't want to wear a mask because it's an infringement on my freedoms or whatever, that doesn't fly in the private workplace. And same with the political stuff. So an employee doesn't have a First Amendment right in the workplace. An employee has a First Amendment right to go outside and protest on the street, and the government can't stop them from doing that. Obviously, there are limits. But in the private workplace, you're able to set parameters for what those employees are talking about. And you can say, look, the recent events and political events and Trump and Biden, all that's going to do in our workplace is create consternation. And so we don't want employees talking about it, because we want you guys to focus on your work and not on all this other stuff that's just going to get everybody mad. And you're allowed to do that. And if an employee continues to sort of fuel the fire with baiting other employees to talk about political stuff, or in violation of your directive, you can absolutely fire that person. And that person's lawsuit against you is not a First Amendment lawsuit, because you're not the government. So that's a lot of information, but just to sort of tie it all together.
Well, I know, because I've just seen so many reports lately of, employers really struggling with the division that it's causing within their workplace, which, it's already difficult enough. And but I haven't seen a lot of answers, so I appreciate that. Hopefully that will give some folks just something to think about. Now, would you recommend, though, let's say the policy is, hey, I don't want any political buttons or T-shirts or hats or, anything like that. Would you recommend that they publish like a written notice of that, or is that something they can just announce at the next shift or the next day, or is that something they should put in writing?
So I would have them, I would really strongly recommend you put it in writing. And because if you just tell your supervisors, hey, go tell everybody they can't do this, you don't know what that message is going to be by the time it hits you. It's the game of rumor where we all say something, whisper something into somebody's ear. That message is going to change, and perhaps in a way that you don't want it to change. So it could end up getting to your employees as the company doesn't believe in BLM, so you're not allowed to talk about it. Or the company doesn't like Donald Trump, so you're not allowed to, say that you like him. So in order to control the message, I would recommend that you have something in writing, carefully written, that goes to each employee, that tells them what the expectations are. And I frankly would address the First Amendment issue. I would say, look, we understand you have the right to do outside of work what you want to do, and the government can't come after you. But inside the workplace, we want to promote peace and harmony and good relations. So we're not having people talk about these kinds of things or wear clothing with political statements on them in the workplace. You will recall, however, that Starbucks just got in a big kerfuffle where they had an employee who was wearing a BLM button, I think it was, during the Floyd issue, where a lot of folks came to the employee's defense, and they should be able to wear this. So really, you've got to just craft the message very carefully and then enforce it consistently. But it really comes down to, what does your company believe? And is this a problem? And are we willing to come out and make a written statement where we prohibit employees from doing this? And frankly, if it is causing consternation and it's causing problems, I think you ought to do it. And I've recently written such a statement for an employer who is a government contractor who had a bunch of people coming to work wearing BLM gear, and then had a bunch of employees coming to work wearing some really anti-BLM gear. And you know, you can imagine where this would go, nowhere good. So we wrote a statement to say, you know, it was a statement kind of about the George Floyd stuff. Like, look, we as a company think this is terrible what happened to this guy. It is reprehensible, and you know, we're people and we're conscious of these kinds of issues, but in the workplace, we've got to be respectful of our government customer, and we have to be respectful of each other. We just don't feel like having these discussions in the workplace is a good idea.
Well, I think that's helpful. Well, let me ask you this. So because we've kind of talked about, it seems like maybe you know, in the employment at will kind of context. But let's say I have an employment agreement. Can I still get laid off in a reduction of force? Can I just get terminated because, you know, I don't know, I'm just not doing a good job? And does that change kind of the discussion we've just had if I have an employment agreement?
It does. So it changes it significantly. So the thing you would want to look for in an employment agreement, if you're thinking about terminating an employee, is, first of all, does that agreement provide for at-will employment? Sometimes it does, many times it does not. Many times it only allows you to terminate the employee for cause. And so what you need to look at is, how does that agreement define cause? And a lot of employers will say, well, this is cause because it's X. And I'll look at the employment agreement and I'm like, well, what you're describing doesn't fit into any of the categories that you've used to define cause. The term cause has no independent meaning in the law. You won't look at Tennessee law and find cause for purposes of an employment agreement. It only is defined by what's in the actual agreement itself. So if you think an employee has done something to constitute cause, you know, don't guess, take a look at that agreement or have it reviewed by your lawyer to make sure it actually fits. It may be that what that person did was bad or awful or whatever, but it doesn't fit into cause. And so the only way you have to terminate that employee may be to either wait until the end of that current term of employment and not renew the agreement, or terminate them at will, but pay them out some sort of severance. And nobody wants to pay a severance when somebody's done something bad or is an underperformer, but that may be the only way you have to get out. I've also seen a lot of employers who call me and say, well, we want to terminate this employee and the reason doesn't fall within the cause provision. And I look at the term and it just renewed 30 days ago for a new 2-year term or whatever. And I'm like, gosh, if only you had called us, 45 days ago, we could have helped. But employers don't realize, this, like, keep up with this stuff, because you may come to an end of a term and it's a perfect time to say goodbye to this employee and, no hard feelings. We're just at the end of our term. The other thing I think you want to keep in mind is, if you are entering into new employment agreements with employees now, or you're coming to the end of these terms where it's a natural time, you want to keep the employee, but rather than renew the old agreement, let's come up with a new agreement. Let's come up with one that's more favorable to you. So, and by more favorable, I mean, you have more options as an employer to terminate the employee for cause. So we would expand the cause provision to make it much broader and give you much more discretion to terminate that person. But we'd also want to add a couple of clauses that have been informed by the current situation. One would be a force majeure clause. And we would want to define that force majeure clause to include pandemic. Force majeure is basically means that everybody agrees that things have gone so bad in the world that we need to terminate this agreement. So something like a pandemic would be included. And that gives you sort of an extra extra way to terminate that contract that you might not have had before. Another thing employers are asking me to do is include in employment agreements some sort of ability to terminate the contract for economic hardship. These are kind of hard to, it's kind of hard to get the prospective employee on board with this, because they're like, gosh, there's a lot of uncertainty there. But if we can, put something in that contract that just gives that employer some sort of ability to say, look, our finances have gotten so bad right now because of the economy that we just can't afford to continue to pay you $5,000 a month for another 12 months. So we need some sort of relief from that. And so if we can include some sort of objective measure, like if the company's revenues go down by X%, we can get out of this contract. So as you're looking at your current employment agreements, as they're expiring and are coming up for renewal, or you're looking to hire new employees, thinking about your employment agreements in a new way, sort of informed by what's going on.
I think it's really good advice, because I think, even in my world where I'm doing a lot of commercial transactions, even acquisitions, I'll get presented a document that I recall preparing 5 or 6 years ago that someone now has kind of played around with, I guess, and I'm like, I kind of recognize that, but now it looks more like Frankenstein than it does what it was originally designed for, or it was just so old, but things have changed. And I think it's always good to keep up with your agreements and make sure that they're, I'll say current, meaning addressing current issues, but also current law and best practices as well. So I think that's really good advice. Now, lately, with the coronavirus, we've had a lot of people, maybe they've had to take FMLA leave, or they've taken leave under the Families First Coronavirus Response Act, to take care of somebody, or child care, or, all of those different reasons. And then, they're gone for whatever period of time they're gone, and we realize, hey, this place is actually, maybe we didn't need the employee, in some moments like a redundancy kind of thing, or, actually this place works a lot better because so-and-so's not here, and, he or she we realize now was just not a really great employee. And I really don't want them to come back. Can I terminate that person while they're on leave, or do I have to wait until they come back and then wait another 6 months or so before I can maybe get rid of them?
Yeah, so this is a really hard issue, and a lot of employers have figured out, as people have gone on leave, they're like, gosh, Sally Sue was causing a lot of consternation back there in the warehouse, and now the warehouse is great, and we like not having her here. So the problem, of course, is, I mentioned early on when we were talking about at-will employment that you can't terminate somebody who is engaged in protected activity. And protected activity includes taking leave under the FMLA or taking leave under the FFCRA. So you can't terminate someone for taking leave, right? But the case law is consistent that an employee taking leave under one of these laws, like the FMLA, is not entitled to any more job protection than any other employee. It's just, here's the thing, if you terminate somebody who's on leave or who's just come back from leave, you're probably going to get a lawsuit. So you just need to set yourself up to defend that lawsuit. And that means, having gone through all the other things we've talked about, you have a good justification for terminating that employee. So if that employee comes back, you say, look, the performance was terrible. It's been terrible all along. And now we've decided, it's, now we have to do a layoff. And so it's natural that this person should be one of the people laid off. Look at how you've selected the person and how do they compare to other people. If Sally Sue's performance is mediocre, but so are 6 other people who didn't take leave, and you're only terminating her, you're going to have a problem defending that termination. So you just need to make sure that if you select Sally Sue for termination, you've got a good record for doing it based on all the things we've talked about today, and make sure that the decision isn't really motivated by the fact that the person took leave, or sort of, really can't be justified as compared to other folks who didn't take leave. So go through all the good steps that we've talked about and make sure you have a good reason to terminate this person.
Right, and I'm just going to interject here on, because we've talked about, I think, a lot of the, I'll call the big issues that I think employers now are currently having to face in terms of how do I reduce my workforce or how do I terminate in these very challenging times. And I manage, as you know, and you've helped me with this, global employment for many clients of ours in different parts of the world. And what I also want to add here is if you are thinking about reducing or terminating employees that you may have that are working in other jurisdictions, that you really consult with a lawyer and help you through that process. Because one thing that I have seen is countries are addressing these challenges in very different ways. In some countries, it is almost illegal to fire anybody right now. In others, you have to jump through, 50 different hoops and get approvals by different government agencies and bodies, and it's very, very challenging. But there's also, for example, in some countries, a lot of relief available to you as an employer, much like, say, our PPP program was here. They have similar programs, but they're they're longer running, meaning they'll take you further along, and you may be able to take advantage of some of those programs. So again, I think this is great for the U.S. I know many of our members also have global operations, and that they should really think long and hard about how they're going to address those employment needs in those different countries, because they're very, very different than they are here. And even within the EU, for example, that you think of somewhat as a more homogeneous kind of region now, that really even there, each country has different programs and different requirements before you can terminate, because of course how they've adopted the directives from the EU are slightly different. But I just wanted to throw that in there because I know we have some of our members, have these global operations. And that's something that, again, seeking good counsel there, I think, can be very helpful. So let's now I know we've got about another 10 minutes. So if anybody has any questions they'd like us to answer, just please type them in the chat. Now, Martha, one of our participants asked a question, and it was interesting, and I've been waiting for the right time to kind of ask it, and I think now we're kind of coming towards the end. So basically what they're asking is, well, are there safe harbors, meaning are there certain reasons that I can always give that will, if I understand the question correctly, that will kind of be my silver bullet? I'm restructuring, or something like that, or is it really now, based on what I'm hearing from you, it really seems to be more fact specific? But are there some like safe harbors or magic bullets?
Well, so restructuring or reduction in force is a good reason to terminate folks. And in fact, if you go to court, if somebody challenges that and you go to court, the employers get a little bit of a break, because the presumption is, if it was truly a reduction in force, the presumption is that was the true reason. And so the employee has a little bit of a harder burden in that situation. But you need to make sure it really was a restructuring or a reduction in force, and you didn't just fire that employee and then hire somebody else to do exactly what they were doing. So don't call it something it's not. The sort of silver bullet answer that I always give is not meeting performance expectations. So that's really broad. That encompasses a lot of things. So performance expectations include things like coming to work on time and not being a jerk to customers, and being professional the way you talk to others, and doing your job. So that's kind of, if I had to throw out one that's a fairly good fit in most cases, not meeting performance expectations is a good reason. And that enables you to use to throw everything in if you end up having to defend the decision, to say, there were 18 things that this person did, all of which constitute, not meeting performance expectations. So,
Martha, what about role eliminations?
So role eliminations, again, great reason to terminate somebody. So you just say, position has been eliminated. And then, what you'll want to do is make sure you don't refill that position, as I said, 6 weeks later with somebody else. Make sure it really is an elimination. And then, of course, you're free to distribute that employee's duties to other employees in the department. or somebody outside of the department or whatever, but position elimination is a great reason.
Thank you.
But these are only, oh, go ahead, Mark.
No, I was just thanking for the feedback.
But, you know, to the extent, for example, we're going to do a force reduction or eliminating a role or all that, it's only as good as my process by which then I actually went through that. So, for example, all the things that I've learned today, I need to actually go through it and think about why am I reducing this person versus, say, the other person across the hall that has the same job and things like that, correct?
Exactly. So if you've
well,
got five
like the
people in this
performance.
position, yeah, why are you picking?
Yeah,
why are you picking Sally Sue
right.
and not picking the other four?
Right. So, you know, we also hear, and you and I have traveled out to some of our clients to have these conversations where they'll tell us, oh, but, you know, the supervisor just keeps coming into my office and they just say, you know, employee X is just horrible and I want him fired, and then they leave, and they expect something to happen. So what do we do in that situation? Like, how do we maybe address the needs of the supervisor, but also, you know, again, managing our workforce?
Sure. So, you know, and if in that case, you're gonna look at the performance evaluations, you're gonna look at the employee's disciplinary file. And if you don't see anything that would support what the supervisor's saying, that's the time when you jack up the supervisor. You know, you have the supervisor come in your office and say, you know, what you're doing is passive aggressively trying to get rid of this person. You haven't counseled them. You haven't done a performance evaluation that would let them know what's going on. So no, we're not going to let you just dictate that this person's got to be gone when you're not doing the underlying work to support the termination. And, you know, this may just be a matter of your supervisor isn't very good at what they're doing. And maybe they just need some additional training in how to counsel employees, how to do write-ups. You know, some people are great at writing, some people are not good at writing, and it's just really challenging for them. So instead of doing that written counseling that they need to do, they just avoid it and they glare at the employee and think, well, I glared at them, so they should know that I'm dissatisfied with their performance. And so really this is a matter of training your supervisors to actually do the hard work of supervising. The hard work of supervising means being willing and able to confront employees who are not performing well and giving them a real sense of what their performance is and putting it in writing and following up and being consistent. So, you know, that's a management problem that you've got to address with that manager or supervisor.
Yeah, sure, because they need to understand that the idea here is we're trying to reduce our risk, and if I just fired everybody that you just, for whatever reason, don't like, or then all you're doing is increasing our risk of potential liability and jeopardizing our business. I think that's good advice. So, you know, so we've talked about laying people off through, say, a reduction in force and through terminations. I always hear, oh, severance agreement. Do we use severance agreements like all the time? And when we do use them, what should the folks that are listening, what should they really know about them and how to use them effectively?
So severance agreements are a great way to incentivize an employee that you're terminating to release all their claims against the company, take a little money, and move on. So, you know, ideally, the employee who is being terminated understands, you know, this is a generous thing. The company doesn't have to give a severance. They're offering me one. I have to sign this agreement that has all this legalese in it, but at least I get a little money. Please don't give an employee money without having them sign a severance agreement. There's no reason to do that. All they're going to do with that money is go to a plaintiff's lawyer's office and put that down as their retainer and sue you. So you should never give an employee money as severance without getting something in return. And that something in return is a release of all their claims against you. You all probably know that if your employee that you're terminating is age 40 or over, there is certain language that has to be in that agreement. And if you don't have that language in that agreement, that employee can sue you for age discrimination and you have paid them some money and they can still sue you. So you've got to have that really particular language. They have to have at least 21 days to consider the agreement, or 45 days if it's part of a group termination. They have to have a 7-day revocation period. They have to be advised by the company to meet with or to consult with an attorney to have the agreement reviewed if they want to. So there's all this particular language. You've got to have your agreements reviewed by a lawyer. If this is something you've taken out and dusted off a few times, have that agreement reviewed. But a few more things that you may be able to get into that agreement as well. A non-disparagement clause. So we want everybody to just leave, and let's make a pleasant parting. We don't want this employee to go run their mouth about how terrible our company is. Put a non-disparagement clause in that agreement. And, you know, maybe if you did not get a non-compete or a non-solicit agreement from this employee up front, maybe you ask for that in the severance agreement. You know, if that's important to you. You would make sure that you have something in the agreement that says the employee has returned all their property to you, so you don't get blindsided that, you know, they kept a bunch of files that you need. You know, you want to put a no rehire provision usually in your severance agreement that says, I won't reapply for employment and I don't expect to get rehired with this company. Because if you lay somebody off or terminate them, and then 3 months later they see another job posting at your company and they apply, you're like, oh, you know, I had a severance agreement, but I didn't anticipate that they would come back, and now they can sue you for failure to hire all over again. So you want to make sure you include a no rehire provision. And then also the final thing is, I think it's really important to make the employee say that they have gotten all the pay that they're entitled to. And the reason that's important is because there are a few claims that cannot be waived in a severance agreement. And one of those is a claim under the Fair Labor Standards Act that you were paid correctly. So they can't waive those claims. Now, I always include FLSA in my list of claims as a deterrent, but they can't legally waive those claims. So the best I can do is get them to say, but I wasn't underpaid. There were, you know, I'm not owed any overtime. I'm not owed any wages that you didn't pay me. So that basically takes care of, if they were to use that exception with the FLSA and try to go around it, we can say, no, look, you said in this agreement, you weren't owed any money. You didn't have any you know, any overtime, you weren't paid or anything like that.
Okay, we got 1 minute. So in 1 minute, what are the top things you want people to take away from your presentation today?
Okay, so I want you to go look at your policies, look at your handbook. How long has it been since you've had it reviewed? If it's been more than a couple of years, it's probably time to have it reviewed and revised and updated. You know, at the very least, you would want to include, you know, language like the infectious disease policy for your company, like people can't come to work sick and stuff like that. But you also want to make sure that your termination provisions allow you the most freedom, you know, that you need to get rid of people when you need to get rid of people. Second thing, I want you to look at your employment agreements. What do they look like? You know, how old are they? Are you in, you know, did you have one that you had in 2002 that has just auto renewed every year? And maybe you want to take another look at that and see if you can revise that employment agreement a little bit. And then 3, look at your process for laying off and terminating people. So, and those are 2 obviously separate categories, but what's the process? What guidance are people given for doing these layoffs? What's the checks and balances? Who's involved in the decision? And just make sure those decisions are made on a sound basis, because we know litigation is coming. We know it is based on the statistics from the 2008 recession. Let's be as ready for it as we can be.
Well, Martha, I would have to say this has been great. I mean, you've given us a ton of information that I think is very practical and helpful, especially right now in all these uncertain times. I know I've learned a lot today. I'm going to turn it, so thank you very much. I'm going to turn it back over to Jennifer and Jay to say goodbye. But thank you, everybody. And if you have any questions at all that you didn't ask today, please reach out. I saw that Jennifer posted our contact information in the chat area, and we're more than happy to talk to you offline. So thank you very much.
Yeah, absolutely. Thank you so much, Martha and John. This has been an excellent program, and we will be posting this on our membership portal so that those here today can revisit it. It's such a wealth of information, and I also will push out that recording to our Nashville membership as well so that they can have the opportunity to hear what you said today. So thank you again, everyone. Have a terrific rest of your day. Our next program is September 17th, and it will be on diversity, inclusion, best practices, and things like that. So should be a great panel as well. Thanks so much.
Thank you. Goodbye.
Bye-bye.